Now, 8:30 Geneva time, we are officially launching this event. Excellencies, dear colleagues, welcome to this side event to the 2014 Regional Forum on Sustainable Development, organized by the United Nations Environment Programme, the United Nations Economic Commission for Europe, and the United Nations Development Programme, in partnership with the Geneva Environment Network, your hosts. Today, we are welcoming leading experts and senior justices from the UNECE region to share information and identify regional priorities in promoting environmental rule of law and access to justice in environmental matters. The panelists will discuss the key trends, gaps, and opportunities related to environmental rule of law, including those identified in the recently launched UNEP Second Environmental Rule of Law report, and the work on environmental justice under the auspices of the UNECE Aarhus Convention and the United Nations Development Programme. They will be guided by the moderator of this session, Sean O'Connell, from the United Nations Development Programme. With that, Sean, the floor is yours.
Many thanks, Diana, and good morning, everyone, or good afternoon or good evening. My name is Sean O'Connell. I'm the global focal point also on environmental justice for the United Nations Development Programme, or UNDP, and I just wanted to start by expressing our gratitude and how much of a privilege it is to co-host this event together with the United Nations Environment Programme and the United Nations Economic Commission for Europe. I want to just say a special thank you to the GEN Network, the Geneva Environment Network, and Diana and the team who've been hosting a series of events together for both the Regional Forum for Sustainable Development and the Human Rights Council around the topic of human rights, rule of law, and the environment. So special thanks to the team for really putting a lot of the hard work in behind the scenes here. We have a very exciting session. We have about an hour and 15 minutes, and to ensure as much time as possible for hearing from our experts, panelists, I'm going to very briefly explain a little bit of the objective and introduce the session. So really, we're exploring the environmental rule of law and advancing SDGs 13 and 16 here this morning. As Diana mentioned, we're looking at some of the challenges and opportunities. I think it's worth mentioning from the outset that, as many of us know, or as some of us at least know, that last year at the SDGs Summit, it was a time to take stock of the progress on the SDGs, and it was a worrying time in terms of monitoring some of the SDGs, and in fact all the SDGs that were either not advancing or in some even cases regressing. So really the opportunity now for us from this year onwards to 2030 is to get back on track for the SDGs, including for us here today to explore SDGs 13 and 16. So that's some of what we'll be discussing. How do we get back on track? And in particular, what could be the role of some important justice actors, including judges and including access to justice initiatives. So one of the points, just by way of introduction, is that, of course, the Regional Forum for Sustainable Development is one of a number of important regional discussions and platforms for exploring how to get the SDGs back on track. We do, of course, have the high-level political forum in New York this year, which is going to bring all these discussions together, hopefully, and set a global course for getting the SDGs back on track. So just to say, these discussions we happen here at the European level are going to feed into the important global discussions later this year. So with that, we're going to start by setting the scene, and we're going to start by hearing from Mr. Arnold Kreilhuber, the Director of the Europe Office at the United Nations Environment Programme, and no stranger to the environmental rule of law as a key member, a former member of the UNEP's Law Division. So with that, Arnold, I'm going to hand the floor to you for some introductory opening remarks. Over to you, Arnold.
Thank you very much, Sean, and a very good morning to all of you from Geneva. On behalf of UNEP and our partners at UNECE and the UN Development Programme, I would like to thank you all for joining us this morning to discuss the advances and challenges we face in our region in promoting environmental rule of law. As you know, this event is organized in the margins of the Regional Sustainable Development Forum, and this year the forum is assessing how we are advancing SDGs 13 and 16, among others. And so the hope is that the discussion today will contribute to this assessment by looking at how environmental rule of law, including the promotion of access to justice, can help our region progress on both of these goals and also other sustainable development goals. Because as we face the triple planetary crisis of climate change, biodiversity, and land loss and pollution, we have seen that this crisis is increasingly compounded by other crises, by inequality, by challenges to human rights. And so environmental rule of law can be a catalyst well beyond SDG 16 and 13 for the achievement of the Sustainable Development Agenda. Emblematic, of course, for these crises is climate change, and that serves essentially also as a threat multiplier. It creates new challenges, but also exacerbates existing ones, existing vulnerabilities, particularly for those most affected by the crisis, most vulnerable groups in our society. But we have also seen in our region the increasing challenges posed by the triple planetary crisis around agriculture, water management, the transition to more sustainable energy. And so the impacts of climate change as an emblematic challenge for the triple planetary crisis affect us today, but will affect us significantly in the months and years to come. And I always describe environmental rule of law as the rule of law applied in the field of the environment, but perhaps with two distinct specific characters. One is the scientific uncertainty, best described by the precautionary approach, but then also the aspect of the intergenerational equity. So the rights of future generations in this context are also very, very important, particularly also as we look, Sean, you have mentioned it, to the high-level political forum, but also then to the summit of the future, where, of course, this intergenerational aspect will also be in focus. The rule of law in the field of the environment is essential for equity in terms of the advancement of the SDGs. It is essentially providing fair access by assuring a rights-based approach in the promotion and protection of environmental but other socioeconomic rights. And so the strengthening of institutions, the call for delivering what the international community has promised has been very much at the core of the development of environmental rule of law. Those of you familiar with the evolution of the concept will recall that its origins can be traced back to a governing council decision of UNEP in 2013, the first universal governing council before the inauguration of what we now know as the UN Environment Assembly. And member states at that time have been particularly concerned about a lack in the implementation of environmental law, a lack in the capacity of institutions to effectively implement environmental law, and concerned, of course, by the impact that violations of environmental law have on the achievement of sustainable development overall. So today we will track progress on environmental rule of law. We will do so also on the back of the launching of the second Global Environmental Rule of Law report. You can't manage what you don't measure. So it's important for the international community to keep track, as I have said, on the capacity of institutions, on delivering on the promises the international community has made, which have been encapsulated in many, many laws around the world, including constitutional laws. And what is, of course, very, very important in this whole context is the role of the judiciary. And I believe we will also dive today a bit more into the role of the judiciary. The judiciary has increasingly embraced the role that it has in safeguarding environmental rule of law, promoting environmental rule of law, making sure that environmental law can deliver for people and the planet through efforts like the Global Judicial Institute, on the Environment, which is an institute by judges for judges to discuss and share experiences, share best practices, lessons learned. The capacity of the judiciary has increased around the world, and particularly also in our region. And we will have on this panel today also proponents of the judiciary who will speak to this. But it is still an area where we need more efforts, more capacities, we need more dialogue among the different stakeholders. And so the hope is that this side event today will contribute to this, will bring different stakeholders together, will allow legal practitioners, but also others to engage in a discussion how environmental rule of law can play an increasing catalytic function to help us achieve sustainable development. Goals 16 and 13, but as I have said, I believe the importance of environmental rule of law goes well beyond that. It is really about ensuring a human rights-based approach to sustainable development, fair and equitable outcomes as we address the triple planetary crisis. And so with these few words, I hope you will all enjoy this side event today, and I wish you an excellent discussion on environmental rule of law in the role of achieving sustainable development, and particularly, as I have said, SDGs 16 and 13. Thank you very much.
Thank you very much, Arnold, and thank you very much for setting the scene. It's we take it for granted sometimes as people in this space that environmental rule of law is important, but you set out a very strong case for why it's so important, and not only that, but what it actually means, as well as some of the things we could start to think about to take it forward. So that's a very important context setter for us. And I think in addition to that, I think we're going to ask Su-Yung Huang, Legal Officer for the United Nations Environment Programme, to dive even deeper into what environmental rule of law is and the current state of it across the planet by building and presenting on the UNEP's second environmental rule of law report. Unenviable task, Su-Yung. You have 10 minutes, and the report itself is huge and a reflection of a significant amount of work over a number of years. So best of luck to you, and we'll check back in with you in 10 minutes or so. The floor is now yours, Su-Yung.
Thank you, Sean, and good morning, everybody. Good afternoon and good evening. So I have 10 minutes. So I'm going to dive just straight into my presentation. I'm Su-Yung. I'm Su-Yung Huang. I'm in the Law Division of UNEP, and I had the pleasure of coordinating this work and preparing for the second report on environmental rule of law. And today I want to, as Sean mentioned, this is a huge amount of work and it has about like 150 pages. But today I'll try to focus on like how environmental rule of law and is related to the role of access to justice, also especially in delivering SDGs 16 and 13. Next, please. So let me start with how environmental rule of law and the SDGs are related. So as Arnold mentioned in the beginning, the short answer to what environmental rule of law means is the principles of rule of law applied in the environmental context. And SDG 13, SDG 16, it has a specific target that promote the rule of law at the national and international levels to ensure equal access to justice for all. And these two together, we actually concluded we clarified the relationship between SDG and the environmental rule of law in our first global report, saying environmental rule of law and SDGs are mutually reinforcing, and we need both to be able to make sure that the environmental rule of law is implemented and SDG targets are met. Next, please. So just to give Arnold mentioned about the goals and the objectives of this report, and just to recap, is to undertake global assessment of global trends and gaps related to environmental rule of law, and also we're trying to support countries to promote and strengthen environmental rule of law, and also to benchmark and identify opportunities for future directions and collaboration so that we can advance and implement the environmental rule of law. And with that, we produced this report and launched it last November. Next, please. And the structure of the report is we have 4 substantive chapters, excluding introduction and conclusions. So we identified 4 components and the 4 substantive components of the environmental rule of law. So it's we need a strong, good laws and also like credible institutions and with the capacity. And civic engagement is another like key component of environmental rule of law. That environmental rule of law doesn't only happen in the vacuum of people's participation, and also rights issues. And Arnold mentioned the rights-based approach to environmental rule of law, and environment actions is one of the key components of environmental rule of law, and justice. So today I'll be focusing more on the justice side of the environmental rule of law, and present you some key findings and takeaways from the second global report on environmental rule of law. Next, please. So key takeaways on justice from the report is what we found out is a fair, legitimate, and well-functioning justice system is crucial for environmental rule of law, and also vice versa. And also ensuring equal access to courts and justice is a key is a prerequisite for the equality before the law, and is a very, very important aspect of environmental rule of law. And so how can it be done? And there are 5 ways that we identified. Is 1, to facilitating financial and geographic accessibility, so as to eliminate the barriers to access to justice by the financial and geographic by increasing the financial and geographical accessibility for those who doesn't have financial means, and for those who cannot actually geographically access the courts, so such as indigenous peoples who are living in remote areas. And to providing an open standing, to increase open standing, people will have be able to bring cases to the court, whether it's directly related to them or whether that concern them. And another is overriding the loser pays principle. So we've identified the loser pays principles applied in many contexts. It's also deterring some people and some organizations to bring cases to the courts. And another is creating environmental courts. And now we identify the increasing number of countries have established the specialized environmental courts, green tribunals. So this is also another way to bring more environmental justice to courts, and have courts that specialize in environmental issues. And third, another is to providing training and the information sharing, and also judicial capacity in many countries. Next, please. So global trends, there are a few global trends we found out is one is digitalization of the judiciaries. So as we've seen during COVID, a lot of courts moved to teleconferencing, and then always having Zoom calls and having courts in the Zoom setting. And also we've seen a lot of emergency plans in the judiciaries. And also we've seen increasing attention on the AIs. So, for example, like in the transition, like the Court of the Council of Europe developed ethical charter on the use of artificial intelligence in judicial system and their environment. So we see a lot of more attention is given to the AI and in access to justice. And lastly, we also found that the digital so good part of having the digitalization of judiciaries is somehow is more accessible to some people, but also this created another gap in some people without the proper internet or good internet connection. They are even having even harder time actually to access to justice. Next, please. And another key trends that we have seen in the access to justice is the increasing number of climate change litigations. And this is also have seen in our UNEP's climate litigation report. And then this another report that we have updated last year shows the number is increased. The number has increased drastically, and it's like really an unprecedented pace. And it's the cases is the purpose of the cases is one is to remedy inaction, so that citizens and the people are challenging the governments and then try to remedy that your action for climate change is insufficient, so calling for more actions. And second is to challenge specific projects. So there's specific projects on development or climate change, climate adaptation or mitigation programs, or to hold the companies accountable. This is another like key findings that we have. So besides challenging governments, branches of governments, we've seen a lot increasing cases that challenging our government companies' responsibility on this. And another key findings is we have on the climate change is there are increasing cases that is relating climate change, linking climate change and also like human rights. So that's another key findings that we had, and we believe that there's going to be more and more cases that's coming up on the climate change and the human rights. Next, please. And this is just to show you how the number of climate change litigations have increased from like 2017 and 2022. There's a drastic change, almost doubled over the past few years. Next, please. So third, the global trend in access to justice is another finding that we have is a number of the remedies are being the remedies by the court is very various. Courts are granting an increasing number of and a variety of remedies. So they have been very creative. Also, besides the traditional remedies that they have ordered, so orders to restore environmental harm, and also there are like a lot of symbolic compensation to governments or the companies that to remedy the situations. And also they have established the programs to educate the public, and also injunction to like public authorities to undertake or stop certain activities. And also like another like interesting remedies I have given you that legal mechanisms enabling judges to closely monitor. So the judges are monitoring the progress and the implementation of their orders. Next, please. So this is a last slide, and I think I'm pretty good with the timing. So the key global trends that we found out is also the transboundary liability. So there are a lot more cases brought to the courts about that's the environmental harm that's taking place, not in one country, but in many different countries, where that can be the people bring the cases about environmental damage in one place and in a different courts. So we this is another findings, and we see the trends. This is like the transboundary liability is increasing in many countries, countries and at the global and the regional levels as well. So we see this will be the trend that will keep continuing in the coming years. Next, please. So I will stop here with this a few key findings from the report on access to justice, and happy to answer any questions later. Thank you. Back to you, Sean.
Thank you very much, Soo Young. It's a very difficult task. The report is years in the making. We really encourage you to go online and dive into it. Don't be intimidated by its size. The beauty of the report is that it's very easy to pull out the pieces that are most significant to you and your work. Just anecdotally to mention that the United Nations Development Programme, many of our country offices have known about the report and in its making and have been waiting for its publication to use it together with government partners and CSO partners as a foundation and to orientate some of our work on environmental rule of law, especially working with the judiciary. So I really encourage people to dive into it. It's we're very fortunate to have this resource. And again, congratulations to the UNEP team. Now, I think we have an excellent opportunity to dive deeper into what environmental rule of law is. And as was mentioned from the beginning, looking at some of the challenges and opportunities in advancing environmental rule of law. And to do that, we're going to turn to our expert panel of speakers. We have a very good mix and diversity of speakers. Of course, we have some sitting judges that can really explore the role of the judiciary, representatives from international organizations, from youth and civil society, and some of our panelists wearing many different hats. So if I can just first introduce the panelists and then pose some questions to them. So first, we have Mr. Luc Leversen, is the President of the Constitutional Court of Belgium and is also the Chair of the Aarhus Convention Task Force on Access to Justice and the president of the European Union Forum of Judges for the Environment, a very important regional network of judges that play a crucial role in advancing environmental rule of law. Second, we have Ms. Christina Voigt, who wears many hats, among which the chair of the IUCN World Commission on Environmental Law, professor of law at the University of Oslo, and co-chair of the Paris Agreement's Compliance and Implementation Committee. Next, we have Ms. Fatima Mirdovic, who is a sitting judge on the Supreme Court of the Federation of Bosnia and Herzegovina. And last but not least, of course, we have Ms. Emma Paliorusko, the Advocacy and Policy Coordinator with the Youth and Environment Europe and European Eco Forum. So I'm going to just maybe look to that first question on significance of what was mentioned a little bit by Soo Young and Arnold on some litigation, because we know this is when we talk about environmental rule of law, litigation and taking cases is a huge part of that. So really what we want to look at first is, in light of SDGs 13 and 16 and in climate change and strong institutions and access to justice, what is the significance of this increase in climate litigation, and what is the role of judges and or access to justice initiatives in such actions? In particular, I think Arnold mentioned this from the beginning, what is very unique about environmental rule of law, in particular in the context of advancing the rights of future generations. So let's allow about 5 minutes for each speaker to go through that question. And Luke, if you don't mind, we'll start with you. So Luke, handing the floor to you.
Thank you very much, Sean, for this introduction. And today I will intervene in my capacity of chair of the task force on access to justice under the UNECE Convention on access to information, public participation in decision-making, and access to justice in environmental matters, the so-called Aarhus Convention. There are at the moment 47 parties to the convention, of which 46 from the UNECE region, including the European Union, but also one from outside that region, being since last year Guinea-Bissau. So it's just important to mention that the Aarhus Convention is also open for parties outside the region. So I think we address today a very actual topic that dominates the news. From one side, we hear that the past winter was the warmest on record, according to the World Meteorological Organization. And an increasing number of places experience water shortages, floodings, and other extreme weather events. From another side, we see an increasing number, as has been showed, of cases brought by members of the public across different regions in specific countries and subject matters in the past years to demand effective climate action and to mitigate loss and damages from climate change. Some of those cases relied on human rights enshrined in international law and national constitutions and challenged the legality of acts and omissions of public bodies and private persons. That was in our region, for example, the case with the well-known Urgenda judgment from the Netherlands, the Belgian climate case, or the German constitutional case, also known as the Neubauer case. In other cases, one relied on national and European Union climate law, as was the case, for example, in Ireland and France, and also in the recent administrative court case in Germany. The Aarhus Convention is a legally binding international treaty that offers an important framework that provides a substantive obligation to protect the right of every person of present and future generations in an environment adequate to his or her health and well-being. So I refer to the preamble of paragraph 7 and article 1 of the convention. Therefore, the protection of intergenerational equity is a fundamental tenet of the Aarhus Convention. The convention also establishes important requirements to guarantee effective access to justice, including with regard to broad standing of environmental NGOs and other members of the public, timeliness, review of substantive and procedural legality, effective and adequate remedies, assistance mechanism to remove or reduce financial and other barriers for members of the public to access to justice, and the prohibition of penalization, persecution, and harassment for exercising their rights. Another issue which is highly important in this context of climate litigation and the rule of law is the protection of environmental defenders. And I would like to underline that through Article 3, paragraph 8 of the Convention, it was the first treaty which provided solid obligations to safeguard environmental defenders. We see a significant variety of cases before judges related to climate issues. For example, lawsuits brought against the state or against public authorities, challenging domestic plans and the enforcement of climate-related laws and policies. We have cases concerning environmental assessment and permitting of projects with an impact on climate. We have cases concerning access to information, on public trust and just transition, trade and investment, reducing and trading of greenhouse gas emissions, protection of biodiversity and ecosystems, and also the failure to adapt to climate change and impacts of adaptation. These suits, or there are also lawsuits against corporations and other private persons based on corporate liability and responsibility for climate harms, reduction of greenhouse gas emissions, access to information, and also challenging greenwashing and misleading advertising. These cases are often legally, scientifically, and technically complex. And I think there is a crucial need for courts and other review bodies to have access to independent scientific or technical expertise to resolve them effectively and timely. The topic has with the task force on access to justice, our continuous attention, and was also addressed at the 2022 Judicial Colloquium in Geneva, the 2022 Annual Conference of the European Union Forum of Judges for the Environment in Paris, and the 2023 Aarhus Convention Task Force on Access to Justice and other international judicial fora too. And you can find background documents and other materials on those events on the respective meeting web pages. Given the ongoing climate cases being considered by the European Court of Human Rights, and one expects judgments before summer, as well as the requests for advisory opinions before other international courts and tribunals regarding the obligations to take climate action, it might be, it's not excluded, that we will see new interpretations of international law emerge in this area in the coming period. This would, I think, clearly support synergetic action to implement SDG 16, paragraph 3 on access to justice for all, or SDG 13 on climate action. That as a response to this first question. Thank you very much.
Huge thanks, Luke. You've done a lot of the heavy lifting. You've explored a wide range of different ongoing conventions and cases being taken. But just to pull out two very important ones, we talk about the environmental rule of law. There is no rule of law unless there's the actual law there, the legal frameworks, and in this case, how important the Aarhus Convention has been in driving a regional understanding of environmental rule of law and being translated into national laws. And on top of that, then this call that when cases come forward, judges need this type of access to scientific information, otherwise it's impossible to do their job. So that's a very clear and an excellent context setter for us, and a very clear call for attracting attention towards the role of the judiciary in advancing SDGs 16 and 13. Christina, just turning to you now on this question of the significance of litigation and role of judiciary and other access to justice initiatives. I know you wear many hats, so many different perspectives you can bring to this question. The floor is yours, Christina.
Thank you so much, Sean, and thanks for the organizers for this very interesting seminar today. You mentioned all the different hats I'm wearing. In this particular context, I'm wearing the hat of the IUCN World Commission on Environmental Law Chair. And in this capacity, I'm actually also a board member of the Global Judicial Institute on the Environment, which Arnold Kreilhuber mentioned, and which contributes to the as a forum for judges to the increased capacity of the judiciary worldwide to address the environmental rule of law in their work. Now, coming back to the question, Sean, that you posed to all of us about the significance of the increase in climate litigation and the role of judges in advancing rights, in particular future generations. I think picking up on President Luc Lavrissen's intervention just now, it might be helpful to delve a little bit deeper in this unprecedented phenomenon that we're currently seeing in increased climate litigation, which also Suron mentioned. It is unprecedented in many different ways. Unprecedented, of course, in the sheer number of cases, but that's not the only unprecedented element. We see more and more cases coming forward, but also more and more cases in different jurisdictions, meaning there are more and more countries that see climate focused cases coming up in their judicial system, countries that traditionally you would not expect to see that kind of litigation being brought forward. But we also see climate litigation being brought from more and more diverse litigants or claimants to more and more diverse respondents. And what I'm meaning here is when we look at the different claimants, we see everything from indigenous peoples leaders to elderly women organizations to farmers to children, of course. In many cases, young people, children are the litigants, putting to the focus to the the intergenerational aspect of these cases. When it comes to the respondents of these cases, and Luke already mentioned that we had the first wave of climate litigation against governments, but we're currently seeing many different respondents being targeted, private actors, companies, multilateral companies included, but also individual responsibility, for example, of directors of companies that are now targeted for individual responsibility. So we are seeing increasing range of different actors in this field. But we're also seeing an increasing variety of claims being brought forward. And again, Luke mentioned some of them. We're seeing constitutional provisions being the basis of claims, but also human rights, tort law, private law claims, criminal law. So we're seeing a widening variety of different legal acts, legal tools being used and being applied in the context of climate change. And the latest development is, of course, that we see that move from domestic courts to international courts, including the European Court on Human Rights, the Inter-American Court on Human Rights, and then the International Tribunal on Law of the Sea, and the latest development, of course, from last year, the highest judicial organ of the United Nations system, the International Court of Justice. So we see climate litigation on many different levels, in many different countries, in many different constellations. So this is just to nuance the picture in front of us. And very briefly, let me address some of the commonalities that we see and maybe some of the challenges that may also come back to addressing SDG 16 and strong institutions and access to justice. The commonalities, I think, very generally is an increase in judicialization of climate justice, an area that was previously refrained or limited to the lawmakers, both internationally and domestically, is something now that has come to be the attention of the third pillar of power, and very rightly so, because in a rule of law, and especially bringing in the environment rule of law, all three pillars of power are, of course, equally important, as so are their individual functions. But we also see a stronger focus on the role of law and the rule of law in climate change. We have the science in place. The IPCC delivers every couple of years global assessment reports that provide us with the cutting edge of climate science, but policies are lagging or their implementation is lagging. And here the judiciary, of course, is stepping in with its rightful role in holding governments to account, or individuals or private actors to the laws that they are subject to. We also see, and that's really interesting, that many of the defenses that are being brought forward by the respondents are not successful in court. For example, arguments like our contribution is just a drop in the ocean compared to the overall climate change greenhouse gas emissions, or whatever we do will be compensated by someone else's emissions, the waterbed argument. We see courts time and time again saying this does not apply. Every contribution is relevant to address climate change. Every greenhouse gas reduction matters. And we see a commonality when it comes to the spatial expansion, including transboundary issues, as Sue already mentioned, leaving, climate change being a global challenge that does not stop at the border is something that is consistently now being addressed in many cases, as well as the temporal scope for addressing issues of justice of future generations. There are some differences as well, depending on which courts we're looking at. If we're looking at domestic cases or cases in domestic courts, it is probably the level of jurisdiction where governments, private actors can be held to account, where perhaps also some enforcement modalities apply better than at the international level, and where we also to some extent see some legislative decisions that push the law further in its development. When we look at the international level, these developments are very unique, they're very new. We haven't seen any decisions yet. All the cases are pending. As Luke mentioned, we are expecting decisions or judgments from the European Court of
Christina, I think your sound has just gone there. Christine?
And give the floor back to you, Sean. Many thanks.
Oh, thank you very much, Christina. Excellent. And thank you so much for complimenting so ideally what Luke's contribution was. I mean, I just wanted to pick up on one quick point on how useful the cases have been in terms of unpacking the situation for claimants as well as the respondents. It's fascinating to read the pleadings, especially in those European Court of Human Rights cases. I mean, the Agostino Duarte case, just to say, one of the claimants when the case began was as young as 6 years of age. And it's fascinating to see what the claim comes from this perspective. And it's also fascinating both to read and to hear the responses of the states. And it also gives us a very good understanding of what the current situation for environmental rule of law is. So how did the states see it, and how should we take it forward, what the entry points would be. So thank you hugely for that, Christina. I'm going to turn now to Fatima. I think you have a very unique perspective on the Supreme Court of Bosnia and Herzegovina. So handing over to you, Fatima, on the significance of these climate cases and especially the role of the judiciary. The floor is yours.
You are muted, Fatima.
Apologies, Fatima. Yeah, maybe try again.
Yeah, I'm here. Thank you, Sean.
Apologies. Go ahead, Fatima. We can hear you loudly. Go ahead.
Yeah. Good morning, everybody. and I must tell that it's great honor and pleasure to me to participate in today's discussion. But first, I have to say that I don't feel like an expert here since I'm among leaders in this area. So I'm kind of a pioneer here in Bosnia, trying to make the work of our judiciary in the area of environmental law more visible and to support the organization of the civil society in defining the solution of the problems that they're struggling with. I will also, because of that, I will start with my speech with some update. Because the new thing is that we published the review of judicial practice in environmental protection in Bosnia and Herzegovina last year with the support of European Union. And the idea and inspiration for writing this paper is the result of many years of collecting case law in environmental protection cases and my participation in several very important regional and international conferences like this with the topic on environment, and the achieved cooperation and exchange of opinions and experiences with fellow judges from Europe and the world. I really had great opportunities to talk to people who work with the environmental law cases, and then to realize that it is important for us to our practice make more, because we have some practices, not big or not rich, but we have some cases, and our public should know how our courts interpret and implement international standards, the international treaties that we ratified. So it is very important for us to share it with the public. Bosnia is a very nice country. The nature is great. We have a clean water. We still have springs with drinkable water. We have a forest, and we really have a responsibility to preserve the nature. I found some data on climate changes because I cannot find cases on climate change, and we have not litigation in this area, but we have some good start point because we have some bodies that are responsible for the implementing the Kyoto Protocol. So in 2010, the Council of Ministers of Bosnia adopted the decision on the establishment of authorized body for the implementation of project of the clean development mechanism of Kyoto Protocol. We also have a designated national authority and the secretariats in the entities, and they are assigned to create and maintain public database containing information on approved CDM projects and other relevant information of CDM process at the entity level. Our problem was that we didn't have any systemized database, including the data on the court decision. So my idea was, since we have now some progress in that area, we are trying to publish as many decisions as possible, because we have a portal for the case law at the Supreme Court, the highest court in the country, and we try to make our decisions more visible, to publish them, especially the legal standing from the decisions. Since our law, existing legislation and accompanying regulatory framework do not contain provisions and do not in any way address the problem of climate change, we have to apply general rules, and it is very important to know the principles, especially the ones that Luke was talking about, the Aarhus Convention, the access to justice, access to information. That is very important in any case. It's very important for protection of human rights, and it's the obligation of the court to make it a rule of law functioning in this area. I just, because I was very engaged about the publication, I will mention one decision of our Constitutional Court from 2022 regarding the violation of Article 6 of European Convention for the Human Rights. And pointing that it's very important that the environmental law cases are very urgent, and the period of 10 months waiting for the decision for adjudication in the case of it was about waste management was too long. And they found a violation, and it's one of the very important, the first actually decision of our Constitutional Court regarding this matter. So what we do, we follow the practice of European Court of Human Rights, European Court of Justice. We try to create our databases to educate and train our judges, and to wait that to get some very important case to solve, because I think we have the capacity, even though we are still a country with more problems than solutions, I have to admit. So thank you. This is it.
Thank you so much, Justice Moldovic. And you really given another excellent complementary contribution to what we've heard before, because in Bosnia and Herzegovina, there is a foundation that needs to be laid for this work. I mean, in Europe, these climate litigation cases did not happen overnight. There was a building role of civil society, public awareness, capacity building in the judiciary. And I think Bosnia and Herzegovina is going through this journey right now, where we're seeing growing interest, growing capacity of CSOs. And I think the role of the judiciary, and as you mentioned, judicial activism, it very often takes one judge to really stick their neck out, if you will, and this is an evolution. It's a journey that takes a while, and as UNDP, we're actually delighted to be working closely with some of the members of the justice sector in Bosnia and Herzegovina. And just last year, we hosted a regional seminar on environmental justice for the Western Balkans, and we had some representation there for the Ministry of Environment in Bosnia and Herzegovina. So there's a lot of movement, a lot of momentum. It's a journey, but as was said from the beginning, it's going to take everyone. It's going to take all justice sectors, all jurisdictions. And I think that's very complementary to what we've heard before, and how Bosnia is on that journey. So thank you very much. And now we're going to turn to you, Emma, and the same question, the significance, again, wearing different hats. Youth, we talk about youth. We always say youth are important, whatnot. But youth are showing us that they're not just important as bystanders in this, they're driving these cases, and they're driving this movement. So the floor is yours, Emma, on the significance of these cases and the role of youth and CSOs.
Thank you very much, Sean, for the floor, and especially to the organizers and the previous speakers, and to everyone who is joining today. So yes, as a young climate activist, I am extremely concerned about the future of the planet. Therefore, the rise in climate litigation, the role of judges and access to justice is a critical aspect of our fight for environmental justice. However, not only. So, as previously stated, it is also crucial for advancing the rights of future generations, especially in light of SDGs 13 and 16. So I will give my contribution from the perspective of youth. First of all, the increase in climate litigation represents for us a powerful tool. It allows us to hold governments and corporations accountable for their actions or inactions, and contribute to climate change and its devastating effects on the future. So by taking legal action, we are demanding justice for ourselves and for future generations, who will inherit the consequences of today's decisions. Under these perspectives, we have to remind ourselves that judges are not just arbiters of the law. They are guardians of justice and, of course, protectors of human rights. In climate litigation, judges have the power to interpret and enforce environmental laws, ensuring that governments and corporations fulfill their obligations to address climate change and protect the environment. So their decisions can set precedents and establish legal standards and shape policies that are crucial for advancing the rights of future generations. In particular, accessing justice is key in advancing intergenerational equity. So the principle that present generations should ensure that the rights and interests of future generations are safeguarded. Climate change, I repeat, is not just an environmental issue, but an issue of intergenerational justice. The actions we take today, or that we fail to take, will have profound impacts on the lives of those who come after us. Judges and therefore have a responsibility to consider the long-term implications of their decisions and to prioritize the interest of future generations in the rulings. An example is, of course, the Neubauer versus Germany judgment. So while the plaintiffs did not claim to represent future generations, the court based its decision in part on constitutional responsibilities to future generations, which it found require not only preservation of a climate compatible with life, but also consideration of how environmental burdens will be taken by future generations. So by upholding the principles of SDGs 13 and 16, it is possible to ensure that climate litigation serves as a catalyst for positive change, driving governments and corporations towards more sustainable and equitable practices. It can help us build a legal framework that protects the planet and guarantees the rights of all people, including those who are yet to be born. But accessing justice doesn't not only play a key role in protecting the rights of future generations. So it also ensures that present ones, the youngest ones, including children, can make their voices heard in a safe space. So among others, as stated by the plaintiffs of Future Generations versus Environment and others, the case of 2018, intergenerational equity isn't only between the present and the future generation, but between the generations of today and younger people who face the effects of those decisions made in the present. One of the most worrying trends that we are facing today that is directly linked to this is the shrinking of civic space and the violent repression of young environmental defenders in Europe, which is a clear violation of, among many others, young people's environmental procedural rights. So effective youth participation, for example, fulfills the principle of intergenerational equity, as it ensures that young people contribute in shaping their future. Likewise, as already stated by some speakers before, access to justice provides them with the legal protections and recourse against such threats, ensuring their safety and well-being as they continue their advocacy work. However, besides being key pillars of for a democratic society, I have to say that many are the benefits connected with the exercise of procedural rights from young people. So, for instance, effective access to justice from young people ensures strong enforcement mechanism within environmental laws. In conclusion, I will say a couple of words. So, on the one hand, us as climate activists and young people, we must continue to advocate for climate justice through all available means, including climate litigation and access to justice. We must work together to hold decision makers accountable, to demand justice for ourselves and for future generations, and to ensure that the principles of SDGs 13 and 16 guide our actions every step of the way. On the other side, we need to rely on the certainty that judges consider the long-term effects of the decisions when it comes to upholding the environmental rule of law. Likewise, it is necessary that today the rights of public participation, access to information, and access to justice in environmental issues are exercised by everyone, including the youngest generations, children and young people. So yes, thank you very much. I will stop here and looking forward to further discuss.
Thank you so much, Emma. Just two quick points I want to pick up on. First of all, these cases, they are not decided in a vacuum. And the advocacy that people get behind influences hugely public opinion and, of course, judicial interpretation. Judges don't just look at the black letter of the law, as we know. And so that's a hugely important role. And secondly, on the repression of young environmental rights defenders, as was mentioned, it is the youngest people that are currently alive today who are going to be worst affected, or among the worst affected by the impacts of climate change. They are not finding it easy to mobilize at some of the young age. So it's the slightly older, if you will, young environmental defenders that play a critical role in bridging the gap between reflecting the rights and the concerns of those particularly young groups and taking that forward into advocacy and action. And if they continue to be repressed, that group, the rights of future generations are going to be significantly infringed upon. We're going to actually reverse and go back to you, Emma. We are a little bit tight for time. The next question is on actions and ways forward. So Emma, we're going to go to you now, and apologies, we're going to reduce this, if you can, your contributions to just around 2 minutes, and just focus on 2 to 3 things that need to happen next. And apologies for the urgency, but maybe it's just reflective of the entire urgency of the situation we find ourselves in taking climate action. So Emma, floor is yours. 2 to 3 key actions, and we have some questions pouring in that we'll circle back to.
So sure. So like I will try to reformulate a bit what I thought. So the opportunities as a way forward that include collaboration among the many actors involved in this very important topic. There are various opportunities for collective effort to address the climate crisis and uphold the environmental rule of law. First, as I said before, courts are becoming a battleground basically for climate action. So judges have the power to interpret the laws and make sure that it fits the needs of present and future generations. On the other hand, other actors such as like governments, of course, they have the power of shaping climate policies and making them fit for present and future generations. And with regards to civil society, the collaboration between civil society and governments and other stakeholders is crucial in order to allow that civil society's efforts for advocate that are in the center of the advocacy for more ambitious climate policies are taken into consideration. But not only that, civil society, the collaboration between civil society, governments, and other actors is also crucial in order to make sure that all representatives of society are heard, including vulnerable communities, and therefore it's essential to ensure social equity. Lawyers, on the other side, they also play a crucial role, and moving forward, I see a very good opportunity for collaboration in providing pro bono legal assistance to climate activists, young environmental defenders, and marginalized communities. All these actors play a crucial role, and I would really like to provide a concrete example of possible collaboration among different actors. So one very tangible opportunity for collaboration is the effort that civil society representatives and other actors are doing for calling the recognition of the right to healthy environment by the Council of Europe. So through the adoption of an additional protocol to the European Convention on Human Rights. These would provide a very powerful and impactful human rights-based response to the environmental crisis. So filling the gap between human rights protection and leading to clarifying policies required, and also, of course, fostering accountability, also with a vision to future generations. It would also reinforce and consolidate the legal protection of this right, and ensuring the enjoyment of many other human rights. We as civil society are at the forefront of this campaign for actually calling for such recognition, and it's essential that Europe does not lag behind other regional areas of the world that already have recognized this. I will stop here, and back to you, Sean.
Thank you very much, Emma. Just again, I'm sure if David Boyd was listening to this, he'd be delighted to hear you citing the right to a healthy environment again. And this is a huge opportunity for us. It's still new. There's a chance to shape it, and I think it does hold a very important place. It might be the key to driving some of this action and making sure it's more impactful and rights-based, as you say. Thank you so much, Emma. Justice Mrdovic, if we can hear a little bit from you about what you see as being some of the key steps, both either in Bosnia and Herzegovina or more broadly.
Yeah, of course, I'll try to be short. It's great to see young people, how they're responsible and serious about these things. And what's for sure, some of them will be judges too in the future. So we have to keep this planet as clean as possible to preserve it to them. And what we do inside judiciary, I think, is good. It's lots of networking, knowledge sharing. It's making our work more visible and our standings more understandable to public. So the legal actions can be taken efficiently. And that's what we can do about it. It's very good that we have the forum, EU Forum for Judges on the Environment, that we have a network called the Superior Court Network under the European Court for Human Rights, where we exchange our experiences. And there's also a guide on environment. It's the pretty new publication from the European Court of Human Rights, and we all use it, and I think it's a very good thing, knowledge sharing and communication among all actors. Thank you, that's it.
Thank you so much, Justice Martovic. And yes, the regional networks have been very, very important. It's a knowledge sharing opportunity, and I think it's excellent that you highlighted also some of the almost extra things judges can do. I mean, they can use their platform in many ways, and one of the most important ways is to write those decisions clearly, is to communicate them clearly to the public so that they can engage with them and build on those decisions. We don't want to make the courtroom an exclusive place. It has to be for everyone. So that's very well said, and really appreciate that contribution. Christina, coming to you, if I may, on some of these next steps. Again, coming from many different directions, even from the IUCN one, whether it be access to justice, to judiciary, or in general, what needs to happen. You did an excellent job on setting out the state of play in litigation, the diversity, but what do you see as being important moving ahead?
Yeah, thanks, Sean. Let me move a little bit away from the judiciary to access to participate in environmental decision making. Which also is, of course, an element of the environmental rule of law, that stakeholders, civil society are able to engage in the decisions that address and affect the environment. And here I just want to point to two very important processes that are ongoing as we speak. Arnold mentioned global environmental challenges, global crises, and most of these crises are addressed through international treaties. We spoke about the Paris Agreement, Framework Convention on Climate Change, the Convention on Biological Diversity, and these international treaties may seem far removed from what we as civil society, as stakeholders, as voters can influence. But this is not really the case, because these international treaties have to be implemented through domestic action and through in domestic decision making. And in this context, we are in a very interesting moment of time as we speak. Two examples. Under the Paris Agreement, each state party has to communicate nationally determined contributions, and it has to do that in regular intervals. And the next time this is supposed to happen for every single party is in early 2025. To be very precise, at the latest February 2025. So this is a year from now. And that new nationally determined contribution also shall be informed by the outcome of the first global stocktake from Dubai, which was very much covered by the media addressing the transitioning away from fossil fuels. So the role of civil society, of this civic element in these decision making, is of course now to use that possibility and try to influence domestic decision making processes in informing the content of that next nationally determined contribution. I'm well aware that not all governments involve civil societies and stakeholders in these processes, although they should. And this is, of course, an opening for pressuring on the participation, effective participation in decision making under the Aarhus Convention. The second example, and that's similar to what I just explained for climate change under the Paris Agreement, the second example is under the Convention on Biological Diversity, which addresses the biodiversity and nature crisis. As you perhaps all know, the parties adopted the Kunming-Montreal Global Biodiversity Framework in 2022. Now, this framework needs to be implemented. And in order to implement, every single party needs to submit an updated national biodiversity plan later this year, which means that as we speak, governments are revising, hopefully revising their biodiversity plans in order to communicate them later this year. And again, this is a lever, this is a pressure point, this is an opportunity for everyone engaged and concerned and interested in this field to participate in decision-making processes based on the right to active participation in decision-making in environmental matters. So I just wanted to highlight these two processes that are happening as we speak. It's really right now where the input of civil society, of all stakeholders, is absolutely crucial and needs to be ensured. And with that, back to you, Sean.
Thank you very much, Christina, and yourself and Emma on the same page there, the role of CSOs, and I think we'll have to come back to that. Justice Leverson, coming back to you, again, many hats, but you have your hands on many levers there, and there's many things that you can do and are doing to take this discussion forward, including through regional networks, including through the Aarhus Convention. So what would your 2 to 3 key actions and taking forward, what would they be? Well, the floor is yours, Justice Leverson.
So I think as we see more and more the negative consequences of climate change every day on the one hand, and on the other hand, we see the gaps between what should be done in terms of mitigation and adaptation on the one hand, and what has been promised and what we see on the ground. So I believe we will see more and more climate litigation, and this means, I think, that judicial system should be adequately equipped to address those cases in terms of capacity, I think in terms of training of judges, and also in bringing expertise to the courts. A priority, I think, to work on is on remedies and effective remedies, because it's of course very nice to have nice judgments, but the question will also be more and more how those judgments can be executed, which type of remedies are effective or not. So I think that's a priority. If we look to the region covered by the Aarhus Conventions, we see in various domestic systems that there are still important barriers. So one has to think how to remove these barriers. And looking to the discussions we had in the task force on access to justice, we have seen that national multi-stakeholder and inclusive dialogues to remove such barriers proved to be instrumental in this regard, and we have seen some interesting examples. Finally, I think, of course, networking, exchange of experiences between judges is very important. Let's say within the European Union, we have the forum, we have training programs, and so on. So maybe for the task force on access to justice and its partners, I think maybe we should give priority to organize judicial colloquia and sub-regional meetings, especially to that part of the region where this is less developed. So I think about South and Eastern Europe, the Caucasus, Central Asia. So I think probably for the task force on access to justice and the different parties, that should be a priority to try to improve their exchange of experiences exchange of best practices, training, and so on. Thank you.
Thank you, Luke. I could almost hear an invitation to Sarajevo for you somewhere in what you said. So hopefully, Justice Mrdović, I'm sure you're known to each other, but maybe another visit is needed. So we just have a few minutes left, and I actually want to pull up on some of the questions. And exactly, Christina, one of them is specifically building on what you said. If you don't mind, just looking in a little bit into this question of climate litigation and in tackling other environmental cases, including biodiversity. So you mentioned on the convention side, it's a tricky question, but there is definitely a link in there somewhere, and how important these climate litigation cases will be for advancing other crises like the biodiversity one. So maybe a minute on that, Christina, if you don't mind. And we have a question for Justice Mrdović next.
Sure. I didn't see the Q&A. I do apologize. Thanks, Sean, for pointing.
Sorry for putting that on you there. See what you can come up with.
Nice. No, but it's a very pertinent question, because we've seen this wave of climate litigation, and what we're seeing now is, of course, a second wave that reflects what we've seen in the climate field within nature and biodiversity protection. But we also see cases where climate and biodiversity concerns are much more integrated and intertwined, which of course makes a lot of sense, because we need to protect nature in order to address the climate challenge, which is, of course, very fascinating from a legal perspective, but it's also demanding on judges, because the complexity of these cases becomes even more profound. But I think we will see more and more cases and litigation also focusing on the protection of nature, because we do see a triple environmental crisis: climate change, biodiversity, and global pollution, which cannot be solved in isolation, because they're interlinked and mutually enhancing challenges. Thanks, Sean.
Thank you. A tricky question. Well done, Christina. Thanks for answering that. Justice Mrdović, we have quite a specific question about climate law. This is in the context from someone from Serbia, but also asking about whether there is climate law in Bosnia and Herzegovina, and also maybe just in general as a follow-up question, that why you think there might have been challenges in bringing more environmental cases in Bosnia and Herzegovina in the past, despite the strength of the laws that are there, which we are familiar with, that are quite strong. So, do you have climate law? And also, what have the challenges been in actually bringing cases in Bosnia and Herzegovina?
Well, thank you, and thank my colleague for the question. It's my colleague from Serbia, and we are the same region, same problems. So as I said before, we have a solid legal framework, but not a good one, because we don't have a law on climate change, specifically like lex specialis. But we have principles and international treaties, and we could implement them in the cases. And also, we do not have cases like this in Bosnia. So I expect it to be like more regional issue, because over boundaries, it's very close. States are very close to each other. So, and the challenge is, I would say that our NGOs are getting stronger and stronger. And I believe in them that they will find a good case to bring to the court. We have some interventions, like especially in administrative law. For instance, we have some provisions of climate change in the regulation of spatial planning in Republika Srpska, because our laws are on entity level, environmental laws. So I expect it to be developed more by the practice of NGOs. Unfortunately, we do not have advocates, lawyers who are specified, who have a specialization in environmental law. I don't think even that we have a course at the law school. So there's a lot of space for improvement in Bosnia. So those are the challenges.
Thank you, Justice Mrdović. If I could put one extra plug from our time in Sarajevo last year, was to the academics as well. A number of excellent researchers in Bosnia and Herzegovina who are really digging deep into this case law. In addition, working with NGOs, very important. We just have a minute or so left. I want to give the floor to Sue Young, 30 seconds to add anything, and then I'm maybe going to give Emma, you the final word, so get yourself ready just to see us out. So Sue Young, if you want to add anything which was being discussed just now, over to you.
Thank you, Sean. First of all, thank you so much for this very, very fruitful discussion. So One thing I want to add is so a lot of things that we've been hearing after we released the report is like implementation, and I think a lot of panelists also mentioned about it. So one on implementation, how do we implement it? So, and what is our role as a UN agency is to track the implementation. So what we are planning to do more, we've done it actually in the second report, is I developed legal indicators on environmental rule of law and tracked how that's going, and globally also at the regional level. So this is we see this is the new area that we really need to work on more. So the development of like good legal indicators on environmental rule of law, and also that use it to see how the environmental laws implemented. So that will be our next step to assist the member states and also other stakeholders and judges and young activists and all the others in improving implementation. Back to you, Sean.
Thank you, Soo-Young. Good opportunity for a bit of a plug there. I will take the same opportunity just to say UNDP in particular in the region is looking at growing those judicial networks. We've had a lot of support from Justice Leverson, both in Central Asia and most recently in the Western Balkans, in particular through our country office in Bosnia and Herzegovina, and with great support from our Istanbul regional hub. So huge opportunities, but we see judges playing such a crucial role together with NGOs, and actually, in fact, national human rights institutes, which again, our colleagues in North Macedonia are supporting. So Emma, we want to give you the final word. You've touched on so many important things in terms of CSOs, yes, youth rights for future generations, but in particular, the right to a healthy environment. So as a final message too, you have just judges on the panel here, you've an audience. What would you like to leave as a final key message?
I would thank you so much again for the floor. I would like to say that, well, as previously mentioned a lot of times, we live in an unprecedented crisis. The ones who will suffer the most from this are the youngest generations of today and the future generations. Therefore, we have to all be on board on the same mission to actually strengthen our efforts towards climate action. One of which is through the recognition of the right to healthy environment at European level, at the Council of Europe level. There are many other ways, such as all efforts to decriminalize environmental defenders and ensure that young people, children, have their say in decision-making processes related to the environment. So thank you very much again.
Thank you very much, Emma. Apologies to everyone for going slightly over time. I first of all, again, want to thank all the panelists. I want to thank all our speakers as well, including from UNEP, Arnold and Soo-Young. And again, congratulations on the publication of the report. It's been an excellent discussion. It's very hard to capture all the main points. If I could pull on three, I want to pull on one that Arnold started with, and it has been touched on here, is that environmental rule of law goes way beyond SDGs 13 and 16. We heard about how it advances discussions on inequality as well as biodiversity. So it's important to recognize the significance of environmental rule of law more broadly, and I want to call on that. Secondly, just to come back on what Justice Leverson and even what Justice Mildovic has said about how important these regional conventions are and how fortunate we are in the European region with the European Court of Human Rights, European Convention on Human Rights, I should say, the Aarhus Convention, as well as even EU law. We're very fortunate. We have a lot of mechanisms to use here, and it's important to recognize as well that there's support needed for some countries in the region to advance and really take advantage of these mechanisms. And I think that was made very clearly both by Justice Leverson and Justice Mildovic. I think finally, the third point really, Christina and Emma really hit on it, which is the role of CSOs, the role of NGOs in advocacy, not just in litigation, but more broadly across multilateral discussions and arrangements. Absolutely crucial, especially now when we see there is some repression going on, and how important a role they play in bridging this gap between the rights of future generations and what's going on now. And I want to have that, there are the three main points, but a bonus one will be what Emma left us with, which is such a concrete thing. Unless we start seeing the issues as climate issues as rights issues, the environmental rule of law is supposed to be there to advance human rights, protect human rights, but we first have to see them as human rights, and then the environmental rule of law can really do its job and play its role. So with that, again, I want to thank everyone, for the panelists, thank all the speakers, thanks to everyone for joining this morning. Apologies for going slightly over, but I think it was worth it to hear such a rich discussion, and hopefully we'll see even more in-depth discussions at the high-level political forum in New York, and see the environmental rule of law continue to grow and play its role in advancing the SDGs. So with that, thank you all very much, and have a good day. Thank you. Thanks again to our colleagues in UNEP and the GEN Network for organizing. Bye, everyone. Thank you.
Thank you. And thank you, Sean, for the excellent moderation.
Thanks, Diana.
Video and summary of the report will be available on the webpage of this event, and the link has been shared many times in the chat.
Thanks for that, Jenna.
Thank
and
you
this
all.
is your last event, Diana. Now you're taking a break.
No, we are active
You're never
on
taking a break.
plastics, a very important topic.
Thanks very much to all the speakers. Thank you, Christina, and thank you, Justice Mildovic. And next time we're in Sarajevo, we'll really try and meet with you. And I really strongly recommend to reach out to our colleagues in the Bosnia-Herzegovina.
Okay, you're welcome. Yeah.